You.
Good morning, Senna, and good morning to your listeners.
I feel like I should be adding doc. Am I right?
Pardon?
I feel like I should be adding Doctor Justice Sai.
Oh, I've been a doctor for years now.
But you've named everybody calls you Justice Sai.
Yeah, because I don't put it out really, but I've been a doctor for years now.
Oh, then I'll maintain the Justice Sai.
That's fine.
I'll maintain the Justice Sai. But it's nice to have you on the line.
Sure.
Yeah. I have seen a program where you were in the studio of, I think, Joy News, speaking to this matter. At the time, the publication Daily Guide made yesterday had not come up. You took a strong view to what the Attorney General is purported to have done. Having seen the Daily Guide publication, does it in any way affect what you said?
I'm sorry, I've not seen the Daily Guide publication, so if you probably could
Okay.
let me in on it.
Well, the Attorney General actually admits what happened, but said he was also taking, so he went to visit a Supreme Court judge. And then, whilst there, Mr. Jakpa appears out of the blue, and they start to have a conversation. And the conversation centered around whether or not the plea bargaining, the judge wanted to find out whether or not they had made any progress in the plea bargaining. And he says no, because the persons involved, including Mr. Jakpa, are not ready to come out openly to admit that, well, they have done something wrong and perhaps then bargain or plea bargain. He goes ahead to even accept that actually there were discussions about the kind of evidence that he should give. But he believes that all this that is being put in the public domain is meant to put pressure on him to discontinue the case, that they have been pressure applied from many angles. It's an extensive account, but I hope I did a good job at summarizing it for you. So there's sort of an admission from him that meeting does take place, but said it was in the presence of a Supreme Court judge.
Okay, so if I understand you, you are saying that it is the Attorney General himself who is admitting this, or is it one of someone claiming to know what happened?
Yeah, this is according to the Daily Guide. They said they are citing a source,
Yeah,
a credible source.
That is fine. So for now, we probably can say that, I mean, to give the Attorney General the benefit of the doubt, he himself is not the one saying this. But whatever it is, this doesn't change. It doesn't change. If anything, it probably worsens the case than it was. I mean, let's break what has happened into two so that we can be as fair as possible to the Attorney General. So there's one aspect of the thing, which is what Mr. Jakpa said in court, which we all found on the court record. Okay. That, for now, is Mr. Jakpa's allegation against the Attorney General. And from the record of the court, there was no denial from the Attorney General. First, that does not mean that the Attorney General has admitted it, because in the proceedings or the stage of the proceedings where this happened, there would be an appropriate opportunity in the court processes for the Attorney General to respond. But for now, let's keep what Mr. Jakpa said as an allegation. Whether it's an allegation or not, it's still a serious matter. Okay? It is a very serious matter, not just to Mr. Jakpa's case, not just to our justice delivery, system. In other words, our criminal justice system, but also a very serious matter to the person or the office of the Attorney General. Now, as lawyers, okay, we have rules, we have ethical rules, some of which are written expressly into law, some of which are just implied, but it is not allowed for a prosecutor to, first of all, try to engage someone who is being prosecuted without the person's lawyer, especially when the person is duly represented by a lawyer. So that is the first. So it is not even about what actually was discussed. The mere approach, the mere communication between a prosecutor and a person, an accused person, to discuss the case without the presence of the accused person's lawyer is a very bad thing. Now, if we go ahead to discuss the case, even in the context of plea bargaining, let me just take some few minutes to explain what plea bargaining is, because it's a new thing in our law. So I'm sure many of us would not really know. But the law was passed, I think, 2022. Plea bargaining simply means that after a person has been, charged or has been charged with a crime or set of crime, either the person or the prosecutor may enter into what we call plea, discussion, as in they show that the outcome of that discussion can be one of three things. First, that the charges in terms of number be reduced. So perhaps, for example, the person has been charged with maybe 10 counts. He may enter into negotiation with the Attorney General so that the number of the charges may be reduced to, say, 3. The second possible outcome is that the gravity of the charges may also be reduced. So maybe the person has been charged with a second degree felony. It is possible that the same conduct could also find place with an offense of misdemeanor. That could also happen so that the gravity of the offense may be reduced. The third thing that may happen is that the charge may be scrapped completely off so that the accused person may be, allowed to go. Whichever way, until and unless a plea agreement, that is a final agreement between the prosecutor and the accused person, is reached, the accused person is innocent until proven guilty. So that is the rule. Now, the reason why I'm explaining this is because we will go to the second part of what the Attorney General has done, which is also wrong. Now, this communication and even the place it happened, I can understand why a Supreme Court judge, you see, we are saying a Supreme Court judge, and it's making it look as if the Supreme Court judge was presiding over the case. No. A Supreme Court judge who probably is also Ghanaian, okay, may be related to someone who is in trouble. And as you know, in this country, we often would talk to people who are able to talk to people and all that. But the fact that we do this social connection and talk to people does not mean, or is not a license for anybody to breach his own rule of, the rule that guides his practice or the office. So personally, I find it quite distasteful that we are placing so much emphasis on the fact that the Supreme Court judge, there's a Supreme Court judge involved, there's a Supreme Court judge involved. I think the Supreme Court judge was using his office as if was presiding over the case as if he's a Supreme Court judge exercising judicial powers. That I can imagine why such a thing will happen. And it could have been anyone. It could have been a Speaker of Parliament, it could have been some pastor, senior pastor of the church, it could have even been a chief. Now, this allegation that Mr. Jakpa made, in a serious, in some jurisdictions where rule of law and fair trial is taken a bit more seriously, it will result in something called mistrial. Mistrial simply means that some serious error has occurred in the process of trial, which should nullify the whole trial. And then a trial delays, that is a new trial that will be ordered. Secondly, if that was done, the prosecutor on the case would be taken off, because here the problem is the person prosecuting the case would have been taken off, and then a new prosecutor will be brought. In this particular case, it's going to be difficult because the person who is involved, who is being accused here, is the Attorney General, who is the ultimate prosecutor in every criminal matter in the country. So taking him off just from prosecuting the case wouldn't be enough, because then he would still have control over whoever is handed the brief to prosecute. So in a serious matter, if an inquiry happens and we found that this is indeed communicated with accused person without accused person's lawyer, in circumstances where the accused person felt that he's been directed to give false testimony, it would have been a completely removal, from the office. But that would obviously happen after inquiry. Now let's move to the other side of the transaction, the other side of things, where the Attorney General himself or through his deputy seems to have offered some explanation. The official press release that came a day after the court date. That for me was so serious that honestly, I thought it shouldn't have come from a high office as that of the Attorney General. Let me explain. When you read the first paragraph of that press release, the Attorney General simply was saying that he has already provided solid evidence on record, which was enough for the accused person to be convicted, and that he wouldn't now be having a conversation with someone whom he has really convicted. And that is, it's sad, because we all know, and Attorney General even knows better, that the fact that you have closed your case and the court said there's a prima facie case, that doesn't mean that you have won the case, because it is now time for the accused person to also speak. So if you put such a thing on record and you publish it at a press conference, you are doing two things. First, you are prejudicing the case of the accused person in the public eye. So you are making the accused person look as guilty already, and you are making it look as if he was guilty by the court process, when you know he is not guilty, at least yet. Secondly, when you put such a thing on record and you put it in the press release, it may get to the judge. So again, you are prejudicing the judge's view of the case. Whichever way, it is not right. Now, he goes on in the same press release to say that it was the accused person to create an impression that it was rather the accused person, in this case, not just the first, not just the third accused person, Mr. Jakpa, but also the first, that is the Dr. Soforti, were trying to get him, they came to beg him and were trying to get him to drop the charges. Again, that creates another impression. And I think that is exactly the impression we wanted the public to have, that even the accused persons themselves know that they are guilty to the extent that they had come to beg him. Now, in respect of the first, Mr. Jakpa, he said, not just he come to beg him, he has engaged other people to put pressure on him, and that he has even entered a plea discussion. He has applied to have a plea discussion or plea negotiation with him. And you see, the fact that a person, that is why I took my time earlier to explain what plea bargaining and plea agreement is. The fact that an accused person has even applied to have a plea conversation or plea discussion with you is no evidence that he's guilty. And in fact, that is why the details of plea bargaining are not allowed to be put out there. Yes, the Attorney General in his press conference has specifically indicated, in fact, he gave the date of the letters that were applied to him, and later, strangely, we found those copies of those letters in media houses or press hands, the hands of journalists. And these journalists, as we have known, are journalists who often are connected to the Attorney General. So even though the Attorney General can come and say, well, I didn't release it, I think common students, native intelligence can give us an idea of what is happening. Now, that truth is very unethical, is wrong, because if you put that kind of information out and you add to it as if, and you talk about it as if that accused person is guilty, again, it's prejudicing the accused person's case, and it's also intended to influence the court in giving a decision from things that are not even on record of the court, because the plea bargaining documentation and the plea bargaining material and discussion are supposed to be without prejudice. It means that it shouldn't even come to the attention of the court. Yet, if it's in the media, the judge will get to know. And then the Attorney General said they were actually asking him they were begging him to drop the case, and they asked other people to put pressure on him. Again, in this country, I can imagine why that happened, and that it usually happens. Even where you sit today, I'm sure every day someone may want you to do some favor which you know are not particularly correct. So in this country, wherever you are, even if your job is to be sharing food at a funeral, you will always have someone who wants to influence you to share the food in a particular way. Now, so the problem is not that he has been approached. And I know and believe strongly that this is not the first case or the only case where someone has approached the Attorney General to do something to favor an accused person. So then the question is, why is he putting this out? He's putting it out because he has an agenda. He wants to make sure that the accused person looks bad in the eyes of everybody, including the court. In any case, if you want to put such a thing out, it should be that you are putting out for purposes of what? Prosecution. Then we know that as an Attorney General, you know that anybody who is trying to influence you to do your work in a particular way, there are offenses for that. So when you are going to put such a thing out, put it out within the context of trying to what? Let's take the person through the law, legal process. But he's not doing so. He didn't put it before a court. He put it in the media, the press release, to have a certain effect. Then the third thing he did, which was against the first accused, is just Dr. Fortin. He said, Dr. Fortin, he has a video of Dr. Fortin, approaching him and begging for the charges to be dropped. That again, not only is that irrelevant to the issue of Mr. Jakpa, the issue that Mr. Jakpa raised in court, it is all these things are completely irrelevant to it. But again, you could see that there is a clear intent to create a certain impression. And it is even wrong for anyone to record someone secretly. And on the show, the spokesperson for the Attorney General was trying to say that it was not a secret recording. But you see, within the context which he put it, who would know, who would go and beg, okay, and try to influence the Attorney General unlawfully, and therefore mercy, when he knows there is a video camera there recording? Even a child will not do such a thing. So the context in which the information was given out clearly shows that this could have been a secret recording. But then again, if you put all together, why is the Attorney General going through all this? Why is he talking about all these things? It tells you that there is something that he wants to neutralize. And that thing is simply that he knows and probably believes himself that what Mr. Jakpa has said is a serious matter, not just for him, but for the case itself.
I honestly think you should get yesterday's daily guide, because on page 12 of the daily guide, the subheading is Jakpa's letters, and daily guide starts that particular subheading with daily guide has also obtained 4 separate letters written by lawyers of Richard Jakpa to the office of the Attorney General, proposing and following up on a plea bargain so that the case will be dropped against him and the other accused persons. Are you suggesting that everything that has happened subsequently only worsens the matter and does not make his case any better?
It worsens the matter because, you see, there are rules for everything. You see, in a criminal justice, when you are prosecuting, okay, first of all, it is the state which is prosecuting. I have been a defense attorney for all these years that I've been at the bar. And anytime you are defending a criminal, the task is huge because, look, when you are in court, the Attorney General has so many privileges that accused person doesn't have. Even though in a proper criminal justice system, in a proper democracy, it should be the other way around. Doubt and confusion should be to the benefit of the accused person. But I can tell you, there are so many things that attorney general gets away with, which even accused person doesn't get away with. So that alone is enough to worsen any case for an accused person. But when you have a situation where, apart from what the system actually, how the system feels towards attorney general, then behind the scenes, these things are going. I mean, how do you do plea bargaining? Okay, if the trial is which has a judge, okay, which has a judge, requires that the accused person be represented by a lawyer. To the extent that even if an accused person doesn't have money to get a lawyer, it is the duty of the state to provide a lawyer. The accused person, that's why we have legal aid and all this. So even at that level playing field in the courtroom, the law says that you need a lawyer. So on what basis would you be engaging a person who is not a lawyer, who has a lawyer on record, to enter into plea bargaining without legal representation? Now, if it's granted that the person says he has waived his right for legal representation, the requirement is that it should be documented, because if you look at the plea bargaining law, it tells you that it should have what do we call it? You should have a record to show that you have told the accused person of his rights, which includes the right to legal representation. It should be on record. Even when you go to the police station, when you go to the police station, and the police are asking you questions, the law says that they have to let you know that you have the right to counsel. And if you decide to waive the right, the police are supposed to take it down, let you sign. So they want the documentation. If the police fails to do that, it doesn't matter what happens. The court will not even admit the statement you have given. So imagine, the whole attorney general is having this conversation about a serious offense like this, a political heavy, prosecution like this, and there's no record of anything, and he's saying that this person waive his right to counsel. So you see, there are serious procedural breaches in all this. And for me, this is a matter which, this is the first time something like this is coming up as far as my knowledge is concerned, concerning an attorney general. In a country where we have a democracy, we still don't have any clear procedures on some of these things. And that's why I am of the view that this is something which requires some inquiry. Inquiry by either parliament or any form of public inquiry, so that we know exactly what happened. We know who has paid for you, with the aim, not the aim of even punishing anybody necessarily, but with the aim of finding out facts and knowing things that can help us to properly arrange our affairs going forward, so that next time we will be able to know that we will be able to prevent some of these things from happening. For example, I even think that even if in the future, if we, after all this, we should be able to make rules regulating even the place where the plea bargaining will be happening. The place where the plea bargaining will happen. I don't think that the law expects plea bargaining to be happening in homes. I don't think so. So such a meeting which has happened in a home should not even be counted as one of the plea bargaining meetings. You see, but here we are, and an impression is being created that plea bargaining was going on, and because the person who is involved is a Supreme Court judge, it could have been a pastor, it could have been a chief, it could have been an elder of a family, anyone could have. So the mere mentioning of, and I know why they are repeatedly saying the Supreme. You see, everything is Supreme Court judge, but and they are trying to create an impression that once the Supreme Court judge is present, then the issue becomes quite judicial. But I don't think the Supreme Court judge was present in his capacity as a judge deciding over anything. He probably is present there in some other social capacity.
I see. So for you, an inquiry is the best way to get to the bottom of this, because your senior Ansari is of the opinion that an inquiry, whether judiciary, parliamentary, or from the executive, will not get us anywhere. That the best forum is for him to go before a judge and exonerate himself. But first, he says the Attorney General must resign. What do you say?
Yes, so that is also a way. I mean, we all know that when things like this happen, the first thought that comes to everyone's mind is that, look, let the Attorney General, let the person resign. Even before the inquiry will proceed, let the person step aside, because the position of Attorney General is quite serious, it's a huge one. He has so many official capacities, especially when it comes to even who advises the president to form a commission of inquiry, or who advises the speaker and the president. It's all about Attorney General. So I can understand why Senior Ansari is calling for him to step aside even before any inquiry goes through. But these countries, things like that don't even happen. But whichever way, there must be an inquiry. We cannot look at this matter, and I don't think it's even a question of the trial court, trying the matter the way we want. Because you see, this issue, are you going to put Attorney General in the witness box to testify? While he's the leader of the bar, he's the prosecutor, and then, there's just so much that the courtroom can't accommodate. So I think that whichever way, whether he steps aside or not, whether he decides to step aside or not, whether he's sacked or not, there ought to be a public inquiry. In fact, the public inquiry is even in his own interest, because I believe he will say that he's innocent and that these things are not as serious as we are saying. So a public inquiry will even help himself to, as it were, tell his side of the story and be given a fair hearing.
Well, it's been very educative listening to you. Thank you very much for agreeing to speak to us and for speaking to us.
Thank you very much, Senna. Yeah. Have a blessed day.
You too. Here is Justice Srem Sai, PhD, Senior Lecturer, Faculty of Law, Gimpa, joining us this morning and having a conversation.